In the last few videos, we've been talking about the private placement process and what a central part the due diligence process plays a role. In this video, we'll be talking about the aspects of a legal due diligence or the chapters that go into the legal due diligence report. Now, these are typical aspects of a legal due diligence that are taken up by most M&A lawyers. These include corporate secretarial, property, debt, litigation, permits and licenses, substantial agreements, and employees. We'll go over each of them one by one. Let's start with corporate secretarial. Now, corporate secretarial is an overview of the company's compliance with the Companies Act as well as associated rules and regulations. So the first question that we really ask is, does the company exist? In which case, you'll need to take a look at the incorporation certificate of the company as well as the articles and memorandum of association. We then take a look at all the filings that the company has done with the registrar of companies. These include the annual returns, the balance sheets, where the charges have been filed for all of the secured debt that the company has taken up. We also take a look at the board and shareholder resolutions. Now, we know for a fact from our discussion in company law that the company really cannot take any decision or cannot take up any action unless authorized by the board. Whether it's the purchase of new property, whether it is getting into a new line of business, whether it is expanding its existing line of business, all of these actions will require board and shareholder approvals. Shareholder approvals are also required for the appointment of the directors of the company, for the appointment of auditors of the company. Has this been done in a verified form? Has this been done in compliance with the Companies Act? And finally, what shares have been issued so far? And what shares have been transferred from one shareholder to another? So what we're looking for under company secretarial is, does the company exist to begin with? If it does, then great, you have a valid target. Has the company complied with all existing Companies Act and related requirements? What are the contingent liabilities of the company? Now, we know for a fact that contingent liabilities are those liabilities that may or may not come up in the future. For example, let's say the company is subject to an ongoing litigation, which, if it loses, will have to pay some amount of compensation. Now, a prudent accountant will actually set aside some money to provide for this liability, which might come up later on in the future. These are known as contingent liabilities. The contingent liabilities are usually found in the notes to accounts of the financial statements of the company. So ideally, in an ideal scenario, all the contingent liabilities that the company has, or all the litigation risk, let's say, that the company has, ought to be covered for in the contingent liabilities section of the books to accounts, which means that we'll need to take a look at whether the company has provisioned enough money to take care of liabilities that are contingent upon actions that might take place in the future. Then we ask the question, what is the profile of the directors, of the management, of the promoters? The reason why we are asking this question is that whether the directors and the management of the company are actually well qualified or experienced enough to run the activities that they do. For example, does your director of finance, does he actually have some financial acumen? Does he have some financial qualifications, experience in finance, so on and so forth? There may be multiple shareholders in the company. It's not necessary that the shareholders are only going to be the promoters of the company. If so, if there are multiple shareholders in the company, is there a shareholders agreement between them? Do they share certain rights and obligations amongst themselves? Rights and obligations which perhaps are not in the Companies Act itself. These are the questions that you should be asking when you're doing a corporate secretarial legal due diligence. The reason why we are asking this question about shareholders is that it's important for us to take a look at what are the existing rights and obligations of shareholders in a company and how we will have to participate in those rights and obligations once our investor becomes a shareholder in the company. Second, we do a diligence on the property that the company owns. Now, we know for a fact that property can largely be classified into three categories. The first is immovable property, second is movable property, and the third category, for the purposes of the diligence, is intellectual property, right? So for movable property, unless if it is extremely valuable, we typically don't take a look at bills of receipt. However, we will take a look at sale deeds or lease deeds of the immovable properties that have been occupied by the company. Now, it is very often and very likely that the company is operating out of a registered office for which it does not have a sale deed or a lease deed. This is a very common feature in many small family-run Indian companies. Another feature that we continuously see in property due diligences is that the instrument that creates the property right in favor of the company is not properly stamped or is not adequately registered. Now, while there is no problem with this as such, particularly if the property is owned by the promoter, we know for a fact that a lease deed or a sale deed that is improperly stamped or is not registered cannot be admissible in a court of law. And therefore, if there are no adequate sale deeds or lease deeds, we would require the company to create adequate sale deeds and lease deeds. Coming to intellectual property, if the company claims that it owns certain intellectual property, it must be in a position to show that it does. For example, they will need to show registrations in terms of patents and trademarks. They will need to show some assignment or some licensing in case they have not created the intellectual property that they claim. In terms of movable properties, you can either have goods or movable capital assets, for example, trucks and cars, etc., for which we typically require to see some kind of motor vehicles registration. So the questions that we're asking is, does the company actually own the properties that it claims to own, right? As we mentioned before, are the sale deeds or the lease deeds adequately stamped? Are they registered? And if so, are they admissible in a court of law? Are there any conditions under which these properties may revert to the seller in case of any event happening? And finally, are these properties adequately insured, right? As a result, what we're trying to find out is that whether the company has adequately purchased enough property, or at least it actually shows that it has the property that it claims, and whether that property has been adequately insured. Now, there was one instance where we were doing a diligence on a company, and this company was somewhere in Gujarat. And we found out that the company did exist, except that they didn't have a lease deed or a sale deed. What they did have instead was a power of attorney by a group of villagers in favor of the managing director or the so-called managing director of that particular company. It was just a power of attorney. Now, we know for a fact that from In Re Suraj Lamps, the case law, a power of attorney does not create property rights at all. In this case, what we did was we advised our client saying that, well, this person actually doesn't own the property, you should not go ahead with this deal. Now, this is an example of discovering risk, right? Continuing on, we now take a look at what is the debt that the company has taken on. What kind of loans have the company taken? What are the loan arrangements that the company has entered into? Most loan arrangements by companies, they consist of three documents to begin with, right? The first is a sanction letter. A sanction letter is a brief document saying that so-and-so lender has in fact sanctioned a loan in favor of this company and the basic details of that loan. How much money is to be loaned? Is it to be drawn down or given to the company all at one go, or is it going to be over a period of time? What is the interest rate? What are the repayment schedules? How much money should the company keep in reserve as margin to maintain this loan? All of this is covered under the sanction letter. The second document that the company should have is the loan agreement itself. Now, the loan agreement is more or less a standardized document which is pretty much the same for all banks and all companies. But the loan agreement will always include a particular clause or a particular term or condition saying that in the case of a change in capital structure, the company must approach the bank for a no objection certificate or must take the consent of the bank, right? So, which means that if the company which has taken this loan under this loan agreement which says you must take the prior consent of the bank, the company is required to get that NOC before the investor actually invests in the company. Why? Because every time there is a new investor that's coming in, it amounts to a change in capital structure. And finally, if the loan is secured, then the loan would be secured by a third separate document which we refer to as the security document. Now, if I'm creating an encumbrance or a lien or some kind of a security on movable property, then it could be either a pledge, a deed of pledge, or a deed of hypothecation. If, however, I'm creating a security on or an encumbrance or a lien on immovable property, we would be having a deed of mortgage, right? Now, we know for a fact, again, from company law that all company loans or charges created by companies are to be filed with the registrar of companies, right? So we'll take a look at whether the company is up to date with the ROC filings, right? And of course, we'll take a look at what are the corporate guarantees that have been made by the company in favor of its subsidiary, its associate companies, its sister concerns, so on and so forth. So, like we've mentioned earlier, we're looking for restrictions of share issuances or restriction of share transfer under these loan agreements that the company has entered into. We are also asking the question that what properties are subject to a charge or a security, and whether the company actually owns these properties. So, for example, when we took a look at the property of the company, if we suddenly find that there is a lien or an encumbrance or a charge created by a company on property that is not claimed to be its own, then we have a problem. Then we go back to the company and ask, all right, you've mentioned that this is the list of your properties, but here is another list of charges and properties on which a charge has been created. One of the properties doesn't show up on your property list. Please explain, right? And of course, we're checking to see whether or not the company has actually filed all the charges necessary before the registrar of companies. Let's come to litigation. Now, litigation is, of course, a very critical aspect of the due diligence, and we want to ensure that any litigation that the company has entered into, it's adequately taken care of in terms of risk allocation, right? So we will require to see all ongoing legal proceedings, the entire paper book, which means starting from the plaint to the response to the to all the evidence that has been recorded in that litigation, right? Any claims that have been filed against the company, but the company has not responded to yet. So any potential legal proceedings as well. What we're looking for is primarily what are the litigations that have been instituted or legal proceedings that have been instituted against the company. We're not so concerned about legal proceedings that the company itself has instituted. The reason being that if there is a litigation against the company could either win the litigation, in which case it doesn't have to pay any compensation, nor does it have to do any specific performance, nor does it have to engage into, let's say, an injunction, right? However, if it loses the litigation, then there might be some kind of injunction, there can be some kind of specific relief that the company would have to do, or the company may have to pay damages. Either way, the best case scenario is that the company remains at the same state as it was earlier. However, in the worst case scenario, of course, the company has to pay damages now. Contrast this with a company that has instituted legal proceedings on its own. Again, there can be two outcomes of this, or variations of these two extreme ends. Either the company starts the litigation, institutes the proceedings and wins, in which case it stands to gain, or it applies for this litigation and loses, in which case the company remains at where it is, status quo. So between a company instituting litigation and a company against whom litigation is instituted, we would be more concerned with litigations against the company rather than litigations by the company, right? We're also going to check, remember we talked about contingent liabilities, we're also going to check whether these litigations are backed up by enough amounts provisioned for within the contingent liability section in the books to accounts, in the financial statements, right? However, there can be a number of litigations that could be potentially ruinous for the company. For example, or they may not be, these litigations may not be directly against the company. It could be against, let's say, a high-ranking executive or a director of the company. For example, let's say a director of the company is facing a sexual harassment suit, which has been widely circulated and widely known. Now, this is a potentially ruinous legal proceeding, something that will bring down the reputation of the company. We also try to look out for these kind of litigations as well, not just against the company, but against the promoter, the directors, and the key managerial personnel as well. We also ask the company for its permits and licenses, primarily for all companies. There will be certain basic tax-based licenses, for example, the PAN, the TAN, the TIN, the GSTIN, right? These are standard for all companies. However, there mostly are industry-specific permits and licenses. So, for example, the electricity sector will have its own set of permits and licenses. The telecom sector will have its own set of permits and licenses. A company that engages in manufacturing will require some permit or license under the Factories Act or under the Industrial Disputes Act. So what are we looking for under these licenses? What we're doing is we're looking for whether there are any restrictions for the company, specifically in terms of the transaction it is about to do, which is issuing fresh shares. For example, in a mining license, in the mining industry, it is not unusual to see the license carrying a provision saying that you cannot change your capital structure without taking consent of the government. Now, this was the main provision in contention in Goten Limestone versus the state of Rajasthan, a 2013 Supreme Court case, where again the court lifted the corporate veil because of public policy. Let's take a look at substantial agreements. Now, there's no hard and fast rule as to what constitutes a substantial agreement, but generally any agreement that accounts for more than 25% of the revenue of the company would constitute a substantial agreement, which means that on the basis of this particular agreement, the company is heavily dependent on this vendor or this customer, right? And that if this agreement were to be cancelled, that the company would stand to lose greatly, because then it would require to change, or it would require to find a new vendor. So here's the question: what are the occasions under which the third party, or the contracting party, may cancel the agreement, right? And are we close to any of these occasions or these conditions, right? Are there checks and balances in place in case a substantial agreement is cancelled, right? So in other words, has the company safeguarded itself against the cancellation of a substantial agreement? And finally, the last chapter for the diligence process is that of employees, right? So what are we looking at? We're obviously looking at a list of all employees, We're looking at the registrations that the company would have had to do under the Employee Provident Fund Act, under the Employee State Insurance or other private insurance. If the company uses contract labor, are they registered as an employer under the Contract Labor Registration Act? We are also going to look at employment agreements with key managerial personnel. Now, key managerial personnel are those people who are critical to the well-being of the company. So, for example, let's say for Apple, Jonathan Ive, who was Apple's head of design for many years, he would have been a key managerial personnel or a key managerial employee. We take a look at the employment agreements with these key managerial personnel. What we're looking for is, if they were to quit, if the key managerial personnel were to quit the company, how long is the notice period? Is it too short to look for a replacement and to train that replacement, right? What we're also looking for is the question that whether the company is in compliance with labor laws and whether or not these key managerial personnel have insurances. Now, a key managerial personnel might leave the company, but it is a possibility that the key managerial personnel may also die while in service. So, do we have enough insurance to cover for any losses in case of the unfortunate demise of a key managerial personnel? So this video has been about the various aspects, the 7 aspects of the due diligence report. In the next few videos, we'll be talking about what are the risks that could come up and how do we deal with them, it as part of the drafting and negotiation aspect of the private placement process.